What's going on, everybody? This is Lady Luck. Okay, we're going to do it. We're going to talk about Super Stupid's unlawful electioneering from the article Illinois Leaks. And there are a couple YouTube clips at the bottom we're going to take a look at. And then we're going to go to a video where there's a comparison that was done. And check out a couple of the board trustees or whatnot wearing some hoodies or whatever. But let's get to it. Okay, so when you're speaking in terms of something being unlawful versus lawful, I mean, step one is to start with the law, right? What I typically try to do is look up information regarding the law itself and trying to kind of get some meaning with it. If I have to look at case law to help understand how the law was interpreted and applied, that's my approach and how I do this, especially when there is, some allegation or accusation of something being, whether it's unlawful or lawful, legal versus illegal. The first step is to start with the law. Secondly, contact an attorney. You don't understand something? Call an attorney, do a consult, or ask questions in general. Me personally, I'm blessed to have someone in my life that I can, ask general questions to, or just get general information on certain things, not in specifics, but, and that being my godmother that I'm going to mention at the end of the video because it's befitting. And you have to look at the circumstance of what's occurring when the alleged violation of the law is occurring, right? So I'm not going to read all of this, but let's just go down to the part where it says here, regarding this is the first time, and probably won't be the last, but it needs to stop. Okay, so Super Stupid is previously used the township bingo games to electioneer, use a food giveaway paid for by the township for campaign purposes, used the township's Facebook page for electioneering, electioneered with Cook County Judge Renee Jackson at a township event, cut in an electioneering video from inside the mayor's office, and frequently urges people to vote for her while chairing public meetings. That she does. We urge any resident voter to file a complaint, Thornton Township Ethics Commission or officer demanding an immediate public hearing on this unlawful electioneering. The law requires it. I'm going to be honest. I don't like Dalton's election board. I just don't. One of the guys looks like Colonel Sanders. Another one just, has wasted time and tax dollars entertaining Michael Smith, who still knows nothing, with their dumb objections that were not even lawfully based. And it's irritating. You guys need a new election board. I'm just putting it out there. They're giving energy to something that no judge in a court of law would even think twice about past 15 minutes. It's just frustrating to watch those election board hearings on one objection against one person. And for some reason, they want to force a subpoena. After two grown men admitted that they go past a state senator's house 50 to 75 times. It doesn't make sense. Why are they entertaining that bullshit? I don't know. But either way. So the electioneering is frowned upon because it is. I mean, it starts with federal laws that speaks to electioneering. And, of course, the Constitution giving states to create state laws. And then, of course, those state laws get passed down to become local municipalities or ordinances or local laws and regulations to follow. They're supposed to basically, beat off of each other. Some states have more restrictive electioneering laws than others. I think Illinois is one of those more restrictive states based on what I've been able to research so far. So we're going to get to that. We're going to get to the law, and we're going to check out these YouTube clips. We're going to also check out a video of I guess, a comparison that was being done with the trustee board or whatnot. And then I'm going to give you guys my opinion on what I think based on the information and how I understand it and how it's been somewhat explained to me from an attorney that deals with election laws, and kind of go from there. So they also notate the Ethics Act defines prohibited political activities and prohibits their activities in Section 5-15, which local governments are required to adopt because they are. State employees shall not intentionally misappropriate any state property or resources by engaging in any prohibited political activity for the benefit of any campaign or for elected office or any political organization. At no time shall any executive or legislative branch, constitutional officer, or any official, director, supervisor, or state employee intentionally misappropriate the services of any state employee by requiring that state employee to perform any prohibited political activity. I want you guys to understand that many of these are based on the intent of the action itself, where you intentionally trying to electioneer by garnering votes in exchange for a butterball turkey paid for with tax dollars. It is the intent there. And then it further reads, subsection I, or 1, however you want to see that. As part of that, employee state duties. 2, as a condition of state employment. Or 3, during any time off that is compensated by the state. So if you're on paid time off or vacation time or anything like that, it still counts. All right. Using a physical office to urge people to vote for her and others for the upcoming elections should be considered electioneering and misappropriation of public property. She does this often. Okay, she put up a video last week where she clipped, cars being lined up, which I've already addressed in a video, where food boxes with her name printed on it were being given out and she used those clips for the purposes of creating a campaign video. So that was done intentionally. It wasn't like a big ass oopsie, because if she thought about it being a mistake made, you would think she would start with talking to the election board or an election attorney about whether or not, if she can just take clips of her giving away food boxes with her name on it and creating a video for the purposes of campaigning herself. So, I mean, even the items in the actual video were paid for by tax dollars. So, let's take a look at one of the clips here that they have, and then we're going to take a look at the second one, and then I'm going to go to this comparison video on YouTube.
9 a.m. to 5 p.m. Make sure you go to Kansas City Library location or South Suburban College. Make sure you punch 1 for yours truly, your super mayor, Tiffany A. Henyard, the people's mayor. And then
I hope you guys heard that. She literally just told you all to vote for her, because context is everything. And the verbiage being used matters when you're speaking of campaigning yourself or wanting people to vote for you. She just gave you all the number to punch to vote for her on the ballot. So, doesn't get any more specific than that. It wasn't like she's just sending a subliminal. She literally just said, vote for me and punch 1 on the ballot. So, let's keep it in the perspective of what's considered lawful versus unlawful and how it would be heard and viewed in a court of law. Okay?
And please support my team as well, because I need a team in order to succeed, of course. Otherwise, I have the same show that's going on currently. My team is Tamika Hughes for clerk, punch 4. And then my board of trustees that I'm supporting is Jocelyn King, Vanessa Westco, and Miss Linda Terrell. That's punch 9, 10, and 11. That's my entire slate. So make sure you go and support our team. Again, I am number 1 on the ballot. I'm at the top, punch 1 for Mayor Tiffany Henyard. Because I always put on
she
for my
repeats herself.
All right, so I just want to throw that out there. The polls are open.
Super stupid. I know you watch my videos, girl. And I'm not even trying to throw you a bone because you got to go. But you keep doing this to yourself. You keep doing this to yourself. I mean, seriously, I would have hoped you learned from my video of you handing out food boxes and putting clips of that stuff together to make a campaign video. I would have hoped you picked some up from there, but no, just keep doubling down. Because I'm going to keep talking about it and clowning you for it. I mean, seriously.
Open February 25th is election day. So if you cannot make it for whatever reason within this 2 week span, make sure you pull up, show out, get out, and make sure you vote. And make sure no matter what, you exercise your right to vote. A lot of people don't understand how important that is for elections.
Oh God, we all know. Okay. I can only deal with this so long with her repeating herself and blah blah blah. All right, let's get to the second one.
Today we had a board meeting. And this is our regular scheduled board meeting. No, I did not show up to that board meeting. I am here, as you can see, in office, in the building.
Did y'all hear that? She's in the office, in the building, in her elected official position, in her office, in the building. Keep that in mind, because she just said it intentionally. All right?
To security concerns. When I got here,
the judge would probably be like, "What security concerns? What does that mean?" All right. Okay. It's a video from Burgundy Blues channel, because I don't feel like finding this on Critical Smokers channel, where she's pointing out some comparisons with the Board of Trustees. And so there is a public meeting going. I don't know when this public meeting was held, but there's a public meeting going, and this is in Dalton now. I think Super Stupid's video was in. Yeah, no, that was. Wasn't that at a Thornton Township meeting though? I don't know, maybe not. But yeah, no, it was the last Thornton Township meeting, because she went there, she got served, and she didn't go in because she keeps citing, safety issues when there's no threat of safety at the time of the meeting or when she arrives. So it's just because she got served. But she didn't go into the meeting itself. And that was Thornton Township meeting. It was Thornton Township. But she was in her office literally and intentionally telling people to vote for her and giving the number on the ballot for the election in Dalton. Yeah, no, you can't do that. But I'm going to pull up the law and show the caveat of what that foretells and why it's important to look at the context and evaluate the circumstance around what's going on when these words are being said. Okay? So let's listen to the trustees say what they're going to say here.
Okay.
See what the issue is.
I'd like to thank the sponsors, right? The people who assisted with making that night possible for the children. We have President Richard Hogan and Kurt Masucci with Private Hogan Investigative Services. The Insurance Exchange.
He hasn't said vote for me yet.
In South Holland, Illinois, and Tristan Sumter who works on property tax appeal and residential and commercial properties. So guys, there's an old adage that says, if you like to go fast, go alone. If you like to go far, go with a team. So I'm just thankful for my team tonight for seeing this mission through, right? As they stated, we're almost at the finish line, and together we can do it. So we are Dalton strong, and let's do this, guys.
I want to thank the faces that actually came out to Abundant Living Christian Center, to the Prayer for Dalton this past week. Thank you each and every one that did come out this Sunday at 11 o'clock.
I want to look at this question down at the bottom from Big Mike. I think this was a live stream going on here. It says also, who's making sure that poll watchers and campaigners are 90 feet away from the polls? It's actually 100 feet. But is there an election occurring right now during this meeting? Is the question. Was there an election occurring when Super Stupid was in her office, hiding from whatever, when she said what she said? So the law is gonna, in good common sense, it's gonna kind of help to understand the nuances in this. And like I said, keep in mind now, we're talking about what's unlawful versus lawful. So you got to imagine when you're looking at this information, even if you didn't go to law school, try to imagine if you were in court and having to explain this to a judge. Because they're not going to really care about your opinion. They have to remain objective and have to go based on what the law says and what the law defines to be electioneering, which also includes what's going on at the time that the electioneering is occurring. So just keep that in mind. I'm trying not to get Bergen's commentary in here because I don't want to just take a commentary like that.
Pastor Fletcher will be serving anniversary for 16 years of being in the Abundant Living Christian Center Church. Each and every one is invited to come out at 11 o'clock this Sunday because Pastor Fletcher has always been here for the community. The doors have been open to each and every one that want to come and do whatever you want to do, to talk about any issues, to bring any type of love or peace together. William Fletcher has definitely been there for the community. So if you, I know everyone belongs to their own church, but if you come by 11 o'clock, we'll be there for a while. And I know it's Super Bowl. I know you won't be there, Cleo. So I know how it is. I know how it is. It's Super Bowl Sunday. But if you can come by and give a little hello to Pastor Fletcher, like I say, his doors has always been open to anyone that want to come in and do anything you want to do. Thank you. Go to their own church, but if you come by 11 o'clock, we'll be there for a while. And I know it's Super Bowl. I know you won't be there.
She rewinded it to hear what Kiana said.
I know how it is. It's Super Bowl Sunday. But if you can come by and give a little hello to Pastor Fletcher, like I say, his doors has always been open to anyone that want to come in and do anything you want to do. Thank you.
So Kiana just said, say hashtag Clean House 2025. Now we're looking at exactly what's being said here. Super Stupid said, vote for me, punch number 1 on the ballot. Vote for my ticket, punch number 9, 10, 11, 5, and something else. So far, the first trustee just spoke in general, never said vote for me or vote for anyone. Stanley Brown, aka Deacon, because he always wearing his Sunday best, just talked about an event at a church. You got to remember how's the judge thinking about this now in terms of electioneering. He didn't say vote for me or vote for somebody around me or vote for people on my ticket. He just spoke in general about an event. Right? Kiana Belcher said, tell them hashtag Clean House 2025. Did she say vote for him? Because a slogan might not be considered electioneering. But saying vote for me and press this number on the ballot could be considered electioneering communication. Now, I'm going to pull up some case law and some law regarding First Amendment, because there's a fine line between electioneering communication and language. What are you soliciting? What are you telling people to do? The information you're giving. Because if you had to just listen to this as a standalone, you don't hear anyone saying vote for me so far. And saying hashtag Clean House 2025 is no different than someone saying MAGA. It's a slogan. But are you telling people to vote for Donald Trump when you say MAGA? Are you saying vote for Jason House and then say hashtag Clean House 2025? So the language and the terminology, what you're saying, and in the circumstance surrounding it, what's going on. This is a public meeting where even they, as the Board of Trustees, have the right to give public comments as well. Those public comments can be considered protected speech under the First Amendment, because they, being the board, they do have, as a part of their standard meetings, they have the right to give comments as well. So bear with me because we're getting there. But so far, I've just heard a slogan, but not vote for Jason House, Clean House 2025. There's a difference in that. She's not telling people which number on the ballot to hit. Neither did Stanley Brown, or I can't ever remember the first young lady. But either way.
Okay. Absolutely.
I'm sorry that, I'm glad you did say that about the prayer. Wednesday, we did have prayer at Abundant Living Christian Center, and we had Dalton ministers and reverends that came out. So I'm grateful that we've started back our prayer for Dalton. It was an awesome time, and just for the fact that we can get churches that's in the community to participate was a really good thing. So I was waiting for him to say hashtag Clean House 2025, but he didn't.
Okay, so that was you guys have seen, Super Stupid give her video, her 2 clips. You just heard 3 Board of Trustees speak their piece. Like I said, the slogan, hashtag Clean House 2025. It doesn't say vote for Jason House 2025. Vote for this person. They didn't even use the word vote. It is not unlawful to say we're having an event at a church, because he didn't even, Stan Brown didn't even say the hashtag. Kiana Belcher did. However, she didn't say vote for Jason House, Clean House 2025. She didn't say vote for me, vote for Stan Brown, vote for us. The word vote was not even used. That does make a difference. Regardless of whether it's a public meeting, you're talking about a public government meeting where they have the right to give their comments as the legislative body. So now we're going to look at the Illinois General Assembly with the ILCS codes. These are basically definitions as they're used in this act. So sometimes there's some nuances to how the law defines a term versus how it might just be defined in standard in a dictionary, such as the word bitch. Yeah, we could look at it and say that might annoy some people, but the law defines that to be protected free speech under the First Amendment. There's also caveats and nuances, meaning what is the circumstances surrounding someone saying the word bitch. So depending on what occurs or what's going on before, during, and after the word is said, could or could not be argued that it could be seen as a fighting word, or to incite violence, or incite an insurrection. It depends on the circumstance surrounding it once the word is said. Stand alone, just saying bitch and walking away, nothing happens. That's protected free speech. And I actually featured that in a video where I brought up case law. I brought up a Connecticut Supreme Court ruling on a case where a woman called a store manager fat ugly bitch and was able to leave the store and go home, and nothing occurred. And the Supreme Court of Connecticut ruled that that was not fighting words. It didn't incite violence. It didn't do anything. She left, went home, and that was it. Store manager didn't engage with her. Nothing happened. But yet the woman was arrested and sentenced to 26 days in jail for being charged with using fighting words. And the Supreme Court of Connecticut overruled it. The state Supreme Court, they overruled and overturned the ruling because it was determined that that's not a fighting word when you consider the circumstance of what occurred. And that's how the law and the courts see that. They have to look at the circumstance and what's going on during the time of the alleged incident. So I'm going to let you all read all these definitions of terms. But it's important to look at how the law defines the term and how it's applied, because that's what matters in court. Your opinion of the word and how you feel and what it garners is irrelevant. The judge has to remain objective and impartial. Preferably they're, non-biased. So they need to look at the legal definition and how the law defines the term, not based on how you feel about it. Because that doesn't fly in court. All right. So I want to look at the legal definitions of two terms particularly. And you guys see member means a member of a General Assembly. Officer means an executive branch constitutional officer or a legislative branch constitutional officer. Let's look at political. Means any activity in support of or in connection with any campaign for elective office or any political organization. And then, of course, there are some limitations to what it does not include. And then you can see the next term underneath. Political organization means a party, committee, association, fund, or other organization that is required, whether or not it's incorporated, that is required to file a statement of organization with the State Board of Elections or a county clerk under Section 9-3 of the Election Code, but only with regard to those activities that require filing with the State Board of Elections or a county clerk. So you guys can go on the ILCS website. This is the Illinois state statute codes here. You guys can go on there under the Illinois General Assembly and read more information. This particular section that I'm reading and looking at is specifically just dealing with the definition of those terms as is applied under this specific act and how it would be interpreted and viewed in court. Okay. All right. Now we're on FindLaw.com. We're looking at the Illinois Statutes, Chapter 10, Elections Statute Code 5/17-29. Political activities within polling places. So Statute 17-29, subsection A cites no judge of election, poll watcher, or other person shall at any primary or election do any electioneering or soliciting of votes or engage in any political discussion within any polling place within 100 feet of any polling place or at the option of a church or private school or any of the property of that church or private school that is a polling place. No person shall interrupt, hinder, or oppose any voter while approaching within those areas for the purposes of voting. Judges of election shall enforce the provisions of this section. What does that mean? I'm glad you asked. That means that this specific statute refers to electioneering during an election. So the question would be, the time that Super Stupid or the Board of Trustees made the comments they made, was it during an election? Were people actually voting? Because logic says, if you sit here and let's say they're, one of the trustees was wearing a Clean House 2025 hoodie, right? Doesn't say vote on it, but in the state of Illinois, it could or could not be considered campaign paraphernalia. If she's sitting in a board meeting wearing that, but no one is in there voting, or it's not a polling place, or she's not within 100 feet of a polling place, would that be a violation of electioneering laws? Well, the statute code is very clear here. So her wearing the hoodie, let's say she's 100 feet from a polling place, she's a candidate, she's a board of trustee, but she's 100 feet away. She can wear the hoodie. But once she gets into that restricted zone during the voting process, during the election, while voting is taking place at the election poll, she will have to take that shit off. And that's what the law says. So, was a voting occurring when Super Stupid said that nonsense in her office, where she literally said, vote for me? No. I don't think anyone was voting that night. Now, I could be wrong. Maybe someone was voting. But it's my understanding, no one was there voting. If people were there voting, though, because I know you guys had early voting to start on the 10th. If people were there voting, and that was considered a polling place, then her soliciting votes at that polling place would be considered a violation of electioneering laws. I'm tongue-tied because I'm tired. But that would be considered a violation of such. She also was in her official office. She's the mayor. And she literally said, vote for me, and punched this number on this ticket. But the question is, was there an election occurring in that building at the time the comments were made? Was that considered to be a polling place? Was there some sort of election occurring when she was there making those comments? That would make the difference. And the same would go for the trustees. If that was a polling place and the trustee wearing the hoodie was still sitting there, if the courts look at that to say, okay, you can't wear logos or anything that helps to encourage voters to go one way or the other within 100 feet of the polling place. If there was an election going on, if there was still voting occurring, that could be considered a violation of electioneering laws, despite the fact that it's not saying vote for someone. It's still affiliated with a campaign. Now, as far as what they said, none of them said vote for me. But we're talking about the hoodie. We're talking about the campaign paraphernalia. Now, the law also states that it's intentional. What I read earlier. Was it intentional? Super Stupid was intentionally telling people to vote for her and repeated herself multiple times. The trustee could present an argument to the court to say, hey, judge, I was there. I wasn't aware. I thought it had to say something like vote for certain, vote for Jason House. Was not aware that this still counted as campaign paraphernalia. I was not trying to utilize this sweatshirt to sway voters one way or the other. I'm sorry, I should have taken it off. To be on the safe side, she should take it off. Just because you don't want that confusion. But there could be an argument made on her wearing that doesn't say vote, but it has a hashtag campaign slogan, or a slogan that is being affiliated with a campaign. If that place was a polling place at the time that the comment was made or that the attire was being worn. But you can't compare that apples to apples with what Super Stupid said, where she literally and intentionally said, vote for me, and punched this number on the ballot. Big difference. Because while they're sitting here talking about prayer Sunday and going to a church, it's not unlawful for you to go to a church unless that church is a polling place. To talk about whatever you want to talk about. And Stan Brown? Yeah. He was careful in what he said, in the phrasing of it. That's why he did not say the hashtag. Because he was being very careful in what he was saying. They all avoided the word vote. But the argument would have to be made that the hashtag Clean House 2025, although having been said as an affiliation of a campaign, the argument would have to be made that they intentionally were trying to sway voters by saying that, because standalone, if you just say hashtag Clean House 2025, most people are going to be like, wait, clean what? If you don't know, you might not even affiliate that with a campaign itself. But that is a big difference. And let's stay objective here. That is a big difference as opposed to someone intentionally saying, vote for me, vote for these people, punch this number on a ballot. Big difference. And the judge will see it like that. He would have to take each scenario and evaluate what was said. Was it intentional? Was there voting going on? Was it a polling place? When the words were said, or the paraphernalia, the hoodie was said, or the hashtag was said, it has to be evaluated in context. So now that you see the law, and this is Illinois state statute, so this would apply across the entire state of Illinois. This is exactly what it says, and this is what the judge, and if there's a jury, this is what they will look at. And if they need something to help them clarify and understand it better, they look to case law. What has precedence been set to be? What were other rulings for a similar scenario? And how did the court interpret this statute code in any other case where someone came, they're a board of trustee, and they were wearing a hoodie. It has a slogan. It might not say vote for Sherry, vote for Carter House. But if an argument is being made here, and I'm pushing the luck on that, if an argument is being made that the hashtag is indeed, easily perceived to be affiliated with a campaign, even though if you were to tell someone who did not know who Jason House was, who did not know anything about an election, and you just imagine you're sitting in a jury box and you say, Clean House 2025, would the average person affiliate that to be related to a campaign? That would be one of the questions that they would have to answer in court. And that would help to determine whether or not it was considered a violation of electioneering laws. So, all right, let's get to another example. Okay, so this is the last article I looked up here regarding First Amendment protections for public comment at government meetings. Because it had to be done. Because we're looking at the example of the Board of Trustees conducting a government meeting. It's a local government meeting, but a government meeting nonetheless. And they were during the portion of the meeting that permitted the board to make comments. They also have the right to make their own public comments. Not only are they trustee members, but they're citizens. They live in that area. They have the right to speak and voice concerns and give comments, as well as any person sitting in the audience. So let's, Lordy, First Amendment is a fickle creature because it's not always concrete, right? Protected free speech and having to draw the line between something being a fighting word versus just saying bitch, or Clean House 2025, or MAGA versus vote for me, punch this number on the ballot. You have to start looking at the circumstance even more, and then utilize case law, Supreme Court rulings to help understand, the circumstance of situations to where you're not violating someone's First Amendment rights simply because they said MAGA or Clean House 2025 versus someone actually saying vote for me. But what was the circumstance and what was going on when they said it? So you guys can go on, this is a Fire website or something. I just looked up First Amendment and I can't pull this up. So here's one of the case laws you guys see here on the First Amendment principles of public comment periods. So the fundamental of all First Amendment free speech principles is that individuals have the right to speak at public meetings, which includes free speech, right to criticize the government. The U.S. Supreme Court explained this core democratic principle in New York Times Company versus Sullivan, 1964, writing of our profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. So, I'm not saying that they were attacking anyone. I mean, this is why I don't feel bad about saying super stupid. You know, you got to grow a spine if you're going to be an elected official, because as you can see here, a case law cited, you might get some criticism and you might not like it. But, you know, you just going to have to get the hell over it if you choose to work in that position. Unless someone is literally verbally threatening to cause physical harm or to unalive someone directly, you have to be careful on what you consider to be a fighting word versus a violation of free speech. It's not always going to be black and white with that, which is, it's a fickle creature. That's why I said that. And it's circumstantial. It depends on what's occurring, when the words are being said, what action occurred after that, or the intent. So those free speech in and of itself, U.S. Supreme Court judges always pen an op-ed, and they constantly talk about how these are seen on a more case-by-case basis. And they're some of the most difficult hearings to conduct, because you want to be careful that you're not violating someone's right to speak freely. And that includes the board of trustees. So, you guys can read. There's more case law here. Matal v. Tam, 2017. Iancu v. Brunetti, 2019. That helps to kind of give some sort of context to how, you know, the First Amendment right, the law is applied in various scenarios in these cases. Texas v. Johnson, 1989, that states if there is a bedrock principle underlying the First Amendment, it is that the government may not prohibit the expression of an idea simply because it finds it offensive or disagreeable. So the trustees giving public comments and speaking of an event would be protected free speech, because they didn't solicit anyone to vote for anyone in those comments. And this article is talking about specifically during a public forum, government meetings to be exact. So you guys can read this on your own accord, but I want to highlight the types of forums that you have. When the government opens up a section of a meeting for public comment, it creates a public forum, of which there are 4 types: traditional public forums, designated public forums, limited public forums, and non-public forums. Courts consider public comment periods to be either limited public forums or designated public forums, depending on the rules the governing body applies. So, of course, there are local municipal rules in the village of Dalton when it comes to conducting these public forums, these government meetings. The courts consider public comment periods to be designated public forums, forums that government officials have opened up or designated for freedom of expression. When the government creates a designated public forum, the government cannot make viewpoint or content-based restrictions on speech unless they meet strict scrutiny, the highest form of judicial review. In other words, when the government creates a designated public forum, that forum holds the government's speak to the First Amendment value just as much as in traditional public forum, which are the streets, parks, and other public spaces society has held in trust for public use to assemble, communicate thoughts between citizens, to discuss public questions. So what does that mean? Basically, this governing body decided to designate an area, such as the town hall at the village of Dalton, to conduct a public forum meeting, a designated public forum meeting for people to come and express their viewpoints, particularly when it comes to their government officials and how government is being conducted. I have a video where Jedediah did a live stream where he was able to catch a hearing between Super Stupid and the Dalton Park District, where the judge reiterated that they have the right to assemble, they have the right to have a meeting, and people have the right to come there to see how the government is conducting business. That includes having a public forum where you open it up in that designated area, of course, but open it up for comments. The board gets to have some comments. The public gets to have their comments and voice their concerns based on whatever ordinances have been established to ensure there's some sort of organization when it comes to that portion of the forum. So if it's 3 minutes shall be given to make your comments and ask questions, whatever, if it's a Q&A session or if it's just comments or what, it should always be a Q&A and comments. It shouldn't just be strictly limited to just a comment because you don't want somebody to ask you a question. That's when you start to restrict the freedom of speech and expression here, because you don't want anyone asking you questions, so you take it out. That could be considered a violation of the First Amendment. Because if someone wants to express themselves through actually posing a question to their elected government official, the First Amendment gives them the right to express that. So that particular ordinance could be deemed or seen as a violation of our First Amendment right to freedom of speech and expression, especially for a designated public forum with government officials. To say you can't say this, but you can say that, it becomes restrictive. And that's when you start to cross the line between exercising free speech and restricting it. Because if someone wants to ask a question, you're not allowing them to, because you don't want to have a question. You want them to make statements that are just general comments. No one cares. That's not how it works. So it's one of the things that the trustees need to clarify and clear up. Get rid of that ordinance or any rule that restricts the type of expression that you have the right to vocalize in a designated public forum during a government meeting. If you want to ask a question, you should be allowed to do that under the First Amendment. All right, so, and then of course the other alternatively, some courts consider public comment periods to be a type of limited public forum, which is one of the government opens for speech serving a particular purpose, such as using a public meeting example commentary relevant to the subjects on the meeting's agenda. When government creates a limited public forum, it can impose viewpoint neutral content restrictions so long as they are reasonable in light of the forum's purpose. Is it reasonable to say we don't want you asking questions? No. I don't see how that's reasonable at all. It also reads down for public comment periods, such as restrictions might include limiting speakers to the subject at hand or the amount of time they have to speak. Government body also can prevent disruptive conduct, such as speaking out of turn or beyond the allocated time limit. Set a reasonable limit on the number of speakers, as long as the government is not excluding particular speakers because of their views. That is something Super Stupid has just trampled over, because how many meetings have been conducted where she had Thunkhead Lacey to try to literally evict people out of a town hall meeting because she didn't like what was being said, even though it was not within any violation of the First Amendment or violation of free speech. So, as I've just read here, the limited public forum, yes, you can say, oh, you can restrict this to 3 minutes, or just we're dealing with a specific topic at hand. But to say you can't ask questions, you're only doing comments, is unreasonable. So when it comes to the comment of the trustees saying Clean House 2025, what are they reasonably saying and expressing here? With the average person, if you got a jury of 12 people and they just hear, I said Clean House 2025, they're going to be like, what the hell does that mean? They're not going to automatically know that it's somehow campaigning for someone or to solicit a vote for someone. That is how those cases are heard in court. So, all in all, you guys can read this, even more. It's a good article. I read through it. And like I said, it's a whole lot of case law in here. So you can always look up case law and read to get an understanding in different scenarios, case by case. No two cases are the same. I can't say that. But it's a very good read, and it helps you to kind of understand, why I say that just certain things is just a violation of constitutional rights, such as saying you can't ask questions, you can give comments only. That whole ordinance needs to be removed. It's unconstitutional. But they can say, hey, we're going to limit down from 5 minutes to 4 minutes because we're limiting it because of the scope or because of time, because of something reasonably defined that continues to maintain order for the forum in and of itself, and to be able to conduct the people's business. So, with regards to Super Stupid and what she said in the aspect of it being unlawful regarding electioneering, like I said, it depends on what was going on. Was that a polling place? Was there voting occurring? There's no denying that she intentionally said to vote for me, vote for these people. But the other examples that was mentioned in the article regarding her buying food boxes and clipping videos, all those things, using government resources in an effort to campaign to solicit votes, that can actually be seen as a violation of finance campaign laws, which are federal laws in and of itself. That's not hard to prove because she has done that. It's his bottom line. She has used tax dollars and government resources, such as taking 2 Thornton Township buses, filling them up with human bodies in it, taking people to a caucus vote so that they can vote for her. So she used government resources in those buses to bus people to a building where a caucus vote was being conducted, where she knew ahead of time that she was not eligible to be nominated through the caucus at all. She just wasn't. She didn't read the rules. She did nothing to be deemed eligible. That's all her fault. Reading is fundamental, Super Stupid. But she didn't do it. And a caucus is a legal electoral process. And you guys can look up Illinois state statutes on that. And he had the right as the caucus leader to have a caucus or a primary. He chose a caucus. She should have did all she needed to do to be eligible. She didn't. That's why the judge threw out her case. Her case was dismissed with prejudice. That means she can't reopen that shit no more. And that's it. And I think the courts are probably going to get sick of her real soon anyway. Because this woman stays in court all the damn time. You Ewok, good grief. Stop using tax dollars to pay for Max Solomon and Bo Brinley's attorney's fees. Bo Brentley, I'm still waiting on you to do some level of retraction or clarification. I don't give a timeline. I'm not doing it. You just know it need to be done. You know that. So, campaign finance law violations, yes. Unlawful or illegal electioneering depends on what was going on. And that's for both. Now, I'm going to say this. I have no respect for Super Stupid in the least bit, and I'm not trying to help her throw her bone. But this is how I would hope everyone would see matters that regard, in regards to the law. You gotta think objectively about it. Okay? Because it's the only way we can fairly, kind of deliver our videos and commentary and research and reporting. You can give your opinion, but when it comes down to a matter of lawful versus unlawful, legal or illegal, you gotta be objective. Just like I did. I just read the information here. I can't make this shit up. I'm not an attorney. I would never want to be one. I can't make it up. So you take this on a case-by-case basis and read and research information. I tell you all to go on these websites. Contact an attorney. It's complicated to understand. A lot of stuff I don't understand. I have to, gauge attorneys and other YouTubers that like Legal, Nate the Lawyer, Debt Free Dad. These are real attorneys. Law Talk with Mike. These are real attorneys whose content I watch regularly. That give very insightful information and very helpful. And then there's always just resources out there to Google. You can look up a summary of electioneering laws. Why can't I say that word? I'm exhausted. Electioneering laws, and just get a brief summary or breakdown of it. All those resources help to understand what's going on, so that certain matters like this, it's not about your opinion. I can have my opinion of Super Stupid all day. But what I can't have an opinion about is how I feel a First Amendment should be expressed. I usually go to the law on that and look up case law. So I hope this is helpful. I dedicate this video to you, Slotamite. I don't know what your name is. But no, this Slotamite said, I don't know anything about banking operations of government. Funny. See, when you challenge me, I'm going to come back and hit hard now. You might want to think twice about that. Oh, no, I'm going to do another video about banking operations, because I guess people don't understand that you just can't call somebody else's bank and get banking information. You just, Jesus. But either way, all right. That's all I got. Oh, let me do this. I want to introduce you all to my godmother. This is the Honorable Judge Linda Walker. And I'm going to do a separate video on her because it's Black History Month. She actually made a lot of firsts in her appointment. She is a U.S. magistrate, federal judge for the Northern District Court of Georgia. And she was the first youngest female and first youngest African American to be appointed to that position. She is not elected. She's federal. She was appointed. So, very proud of her. As you all can see, we look alike. And this is the person that has inspired me to be who I am, and inspired me to continuously learn and be educated when it comes to the matter of our legal system and the courts. I don't know everything. And no, I can't ask her everything. I can't get advice from her or anything like that. And hell, I'm a daughter. But what I try to do is consider what she's taught me about when it comes to things being legal, ethical, and moral. So when it comes down to a topic regarding the law, look to the law to help you get answers. So she was asked, what are some misconceptions? She was doing a podcast here. And she was asked, what are some misconceptions about the law? So I'm going to play just a snippet of the video and let her kind of give an answer to that. And I encourage you all to go on Boss Sleep podcast to look at her full interview. I'm going to do a reaction to it and for Black History Month, because women like my godmother, Black women like my godmother who have made strides to check off a lot of firsts in her life in one appointment, should be honored and celebrated. And she is part of my history. Been in my life since I was 15, 16 years old. And I love her dearly. So I'm going to let you guys hear this from a judge's mouth.
A lot of people misunderstand. One, we watch so much court TV and so many, whether it's Judge Judy, any of the other popular judge shows, in real cases really not like that at all. And it's not as exciting probably as that. It's much more formal. It's much longer. It may be a little more boring than what you see on court TV. And a lot. It's most people will shun it. I mean, they'll say anything. I worship someone so-and-so on Tuesday, so I can't be. That it is an important civic duty, and you do learn a lot about it. You're probably a little bit different. You were somewhat amenable. You're at least open-minded about jury duty. Majority of people do not want to serve. They have these thoughts as to somebody's going to come after you, or I don't want to do it. I don't want to be tied down. I don't want to be sitting in judgment of other people. But it is an important civic duty that we all should undertake at least once. And it's not like court TV. Majority of your legal issues are not even handled in the courtroom. Majority of them handled right here at this desk. And people are always surprised by that, because I'd say, well, I don't have court this week. Well, what do you do when you don't have court? I'm working on legal opinions. And so it's not like court TV. It's a very respectful, very formal institution. And I think because you have so many judge shows, it sort of diminishes the civil servant part of it. It diminishes the importance of the civic duty. And it just diminishes how people interact with the court too. Because sometimes people come in, you're like, this is court. You do realize this is court now, or that you want something from me. Because you're acting like I'm coming to you for something, dismissed with attitudes and things like that. So they think it's like, or they're your friend, like you see on court television or something, particularly the pop-up judge shows.
So that's just a synopsis. Just a synopsis. Court is very boring is the point. Court is boring. So very boring stuff. I'm sure half of you probably fell asleep by the time I hit article number 3, because it's boring. But it's vital and crucial to learn and to be educated, so that, when things happen, it's imperative as to why people should understand why I say that things aren't always comparable apples to apples. In an effort in trying to dehumanize super stupid. Don't try to sit here and say, well, they did this, so I do this. That becomes tit for tat. And it doesn't always work like that when it comes to a matter of law. It just doesn't. And she spoke about jury duty. Let me tell you something, I hate it. But I would love to be on that jury for at least 2 cases. The one with Drake, because, and the one with P. Diddy. I think most of us would probably love to sit in that courtroom and hear that hearing. But either way, and when Super Stupid gets hit with that superseding indictment, I would love to be a jury for that. But, just to help you guys understand perspective and why I take the viewpoint, the approach that I do when it comes to certain topics and issues. I'm not trying to throw Super Stupid a bone, but I have to ensure that the law is read. There's some case law to support it. And then it's evaluated as as it would be if a judge was sitting down listening to it. And some questions would be asked of what was going on, what the circumstances around everything. And when you're talking about, First Amendment rights to freedom of speech and expression, it's always a lot of circumstances around it. And it has to be taken on a case-by-case basis. So, either way, that is all I have. Hope you guys enjoyed that. In all that I get in Google. Read and look stuff up. Because boy, did I have to. My brain is broken. And I'm tired. But I love you, Mom. And I hope you guys do check out her interview. Well, I don't know if it was an interview. I don't know what we're doing. But it's on Boss Sleep Podcast. I'll have the link to that video in the description. I am going to do a full video, like I said, for Black History Month, because I don't think she realizes, like, the first that she checked off, how momentous it is. But she has a sassy side, like mother, like daughter. So, either way, that's all I got. And until the next video, lady, look out. Deuces.